My goal with this video is to give you a jump start to the topic of trademarks and domain names, so that we can focus more closely on the primary issues in the class session. Let's begin with a little terminology. Domain names link words to Internet Protocol addresses, which essentially are a string of numbers that are tied to devices on the Internet. The domain name, thus, is a human-friendly method to reach locations on the web. One component of the domain name is called the top-level domain name, or TLD. It's the last portion, like .com or .edu. There also are second-level domain names, which precede the TLD. Examples would be Apple or Cal Poly. Thus, you might have the domain name apple.com or calpoly.edu. From the very beginning of the web, the most popular TLD has been .com. At first, there were just a few other TLD options, such as .net, .edu, and .gov. There are now far more TLDs, although .com still predominates. Each of the TLDs is administered by what is called a registry. The registry in charge of .com was at first called Network Solutions, or NSI, but it is now VeriSign. From the beginning, the burning question was about how NSI should allocate second-level domain names among individuals that might want them. Should it be first come, first served? If one thinks of domain names as merely internet addresses without any connection to trademark rights, that would certainly make sense. It's also the easiest way to administer the TLD. On the other hand, maybe trademarks should play a role because consumers might use the name to identify the sources of goods and services. But if trademark rights are relevant, that raises a number of potential problems for companies such as NSI that are responsible for registering domain names. For instance, there are several companies selling different products that have legitimate trademark rights to the word Rembrandt. Off the top of my head, I know there's a toothpaste company, and because of my wife, I know that there's an art supply company that have trademark registrations for it. If they both requested the domain name, well, then who should get it? What if there is a company that uses the name for musical instruments, but hasn't registered it? As you know, that's possible. Do they have rights to the domain name? What if there are unregistered users in different parts of the country? What then? What if there's a toothpaste company called Rembrandt in England? What if a company wants Rembrandt.com but doesn't sell anything? That would cause a likelihood of confusion, so is that okay? Well, I could go on, and you can imagine that NSI didn't want to have to deal with these issues. That would force it to act like a referee in trademark disputes. Oh, remember how ISPs didn't want to act like copyright judges? And the registries for trademark domain names felt the same way. For this reason, the registries essentially wiped their hands and went with the rule that the first person to file for a name got it. End of story. Okay, look. Domain names are often used in commercial settings. Thus, you can imagine that businesses often wanted their brands to serve as second-level domain names. This led to opportunities for savvy individuals to make some money. For instance, I could snap up trademark words before the legitimate owners applied for the domain names. It didn't cost much, often less than $10. And when the trademark owner went to register the domain name, they would learn that I already owned it. And so they would have to come to me and offer a price that I found acceptable. In a sense, I just sat on the domain name property and waited for a purchaser, which led to the practice being called cybersquatting. There were other abuses. I could buy up domain names for well-known brands to divert traffic to my site, where I might show ads or sell my own stuff. Or, if the domain name were already taken, I could buy slight misspellings, which would also divert traffic from those making the predictable errors. If domain names are merely addresses without having any trademark implications, then all of these practices would be legal, although not necessarily ethical. On the other hand, if domain names also served trademark functions, then some of these practices might cause a likelihood of confusion or dilution, depending on what is done at the site. Panavision versus Toeppen was the first important court decision to evaluate the relationship between domain names and trademarks. When was this? 1996. What happened? Toeppen was an individual engaged in cybersquatting, and one of the domain names he had registered was Panavision.com. He was kind of clever, and so he actually had a website that displayed a picture of Pana, Illinois. Thus, it provided a Panavision. Panavision was a prominent film company at the time, but they were not necessarily internet experienced, so Toeppen beat them to the registration office. Panavision later designed its website, but when it went to NSI to register Panavision.com, the company was told that the name was not available because Toeppen already had it. So Panavision contacts Toeppen and basically says, hand over the domain name. And Toeppen says, okay, I will, for $13,000. Panavision refuses, and in response, Toeppen registered Panaflex, which is another prominent mark owned by Panavision. The website simply said, hello. Well, Panavision hauls Toeppen into court, claiming trademark infringement. So here we go. To reach a decision, the court will have to determine whether the use made by Toeppen has any association to trademarks, and if so, whether it infringes Panavision's rights. Okay, the court makes it clear that it is entering novel territory, but concludes that the association of domain names with websites may raise trademark issues. All right, that was step one, and an important ruling in and of itself. But now the court had to address whether Toeppen's use infringed Panavision's trademark rights. And this was going to be difficult. So, if Toeppen had been selling film-related products, you might allege that it was creating a likelihood of confusion. Even if he were selling unrelated products, you might argue that Panavision was famous and Toeppen was engaged in dilution. But the problem was that Toeppen was not selling anything. So I think the court was annoyed by Toeppen's behavior and intuitively felt that it violated Panavision's rights. But it was going to have to be a little creative to reach the desired outcome. Likelihood of confusion was probably a non-starter, but the ambiguity with dilution gave the court an opening, and it decided to barge right through it. To begin, the court concluded that Panavision met the criteria for being a famous mark. Next, it addressed whether Toeppen was engaged in a commercial use. And it cleared this hurdle because Toeppen was in the business of registering domain names so that he could resell them for money. The third and most difficult criteria was whether Toeppen's use caused blurring or tarnishment of the Panavision trademark. Tarnishment is out. There's nothing unsavoring going on, and Toeppen is not selling products of lesser quality or anything like that. That just leaves blurring as the dilution theory to nab Toeppen. So blurring means to whittle away the distinctive magnetism of a famous trademark. And the court makes kind of a leap here, but it concluded that Toeppen, by registering the Panavision name, totally eliminated the capacity of Panavision to identify and distinguish its products on the internet. And that was that. Panavision won its infringement case based on dilution through blurring. And the result was that it was able to obtain the registration of Panavision and Panavlex for its own use. And it didn't have to pay Toeppen a dime to get them. Of course, it did end up having to pay its own attorney, and that surely cost more than the 13 grand. But sometimes it's the principle that counts. Okay, well, despite Panavision's victory, this case left a lot of potential openings for cyber squatters to continue their practices. One major hole was that Panavision prevailed based on dilution, which only can serve to rescue famous names. If your company was not in that category, then the extent of your rights over the web were less clear. For instance, if your company made slime tire sealant, then you might be able to prevent another company from selling tire products over slime.com based on a likelihood of confusion. But that might be the extent of it. You probably could not stop someone from cybersquatting the domain if they beat you to register it, because your name is not famous. Also, as just alluded, even if you have a famous name, you would still need to pay attorneys to litigate in court. For that reason, you may be willing to pay a reasonable sum to avoid the risks and costs of going to court. Cyber squatters knew this, and so offered to release the names for amounts that looked attractive in light of the alternative hassles. For these reasons, the Panavision decision was not a sufficient answer for trademark owners, and consequently, they sought other solutions. One focus of their attention was the registry, NSI. Given the court's conclusion that domain names can affect trademark rights, companies put pressure on NSI to take steps to protect the interests of trademark owners when registering domain names. As I mentioned, NSI was reluctant to move too far down the slippery slope of becoming a trademark judge. So it made a few changes to benefit trademark owners, but for the most part tried to stay out of it as much as possible. To this end, the fundamental policy of granting a domain name to the first to file the registration continued. However, if someone beat the slime tire sealant company to NSI and registered slime.com, Slime could show NSI that it had a trademark registration for slime. NSI would then go to the domain name owner and ask if it had a trademark registration for slime in the US or another country. If it did, then NSI assumed the domain name registrant had some legitimate rights, and so it got to keep the name. But if it did not have a trademark registration, then NSI would put the name on hold, meaning that nobody could own it until a court resolved this dispute and directed who should get it. You might ask, why put it on hold? Why not require the transfer? And the answer is because you don't necessarily need a trademark registration to have trademark rights in the name. Thus, NSI's position was, we don't know how to resolve this, so nobody wins until a court directs us how to proceed. Well, trademark owners thought this policy was better than doing nothing, but they were still not completely satisfied. For one thing, it only screened for identical uses and did not account for harms that slight misspellings or typos might cause. Also, even if identical, NSI only put the name on hold and didn't transfer it. This meant that cyber squatters still had leverage to demand a reasonable payment because otherwise the trademark owner had to wait for a trial and pay related fees. Also, as you know, it can be relatively easy to get a trademark registration in some countries. Thus, a determined cyber squatter had a fairly simple path to keep the domain name. Those on the other side of the ledger had reasons to complain as well. For instance, those with unregistered trademarks might lose their legitimate rights to use the domain name while it was put on hold. This outcry and dissatisfaction led to two public policy responses that were intended to combat the circumstances when individuals clearly intended to abuse trademark rights via domain name registrations. One of these responses was through legislation called the Anti-Cybersquatting Consumer Protection Act. This law allows trademark owners to sue in court for statutory damages and possibly attorney fees. As with copyrights, statutory damages here give a judge flexibility to choose an amount that seems reasonable under the circumstances. The range extends up to $100,000 per domain name, which can serve as a pretty significant deterrent to those simply trying to game the system. In addition, the judge can add reasonable attorney's fees, which also may be substantial. Just think how this changes the negotiation dynamics for a cyber squatter. Before the act, a trademark owner could have trouble proving damage and would have difficulty getting attorney's fees. Thus, a cyber squatter might ask for, let's say, $5,000 or so, knowing that a sensible trademark owner would just take it. After the Cybersquatting Act, the trademark owner could credibly threaten to sue for $100,000 plus the tens of thousands of dollars for the attorney. This obviously should make an abusive registrant think twice about asking for too much. Okay, so that was one solution. The other response was implemented by the Internet Corporation for Assigned Names and Numbers, or ICANN, which is the organization in charge of the entire international domain name system. With this policy, ICANN requires all companies registering domain names to provide for an online arbitration process to resolve allegations that a registration is abusive. This process is provided by what is called the Uniform Dispute Resolution Policy, or UDRP. The UDRP procedure is relatively quick, easy, and inexpensive. The trademark owner isn't seeking money, just a speedy resolution of the claim and transfer of the domain name. The fee is like $1,500, so that pretty much caps what an abusive domain name registrant might seek. Otherwise, the trademark owner will just grab it via arbitration. All right, so both of these solutions are aimed at addressing the most egregious circumstances involving domain name abuse. So, what's domain name abuse? The standards for the two approaches are very similar, and I have summarized the basic elements here on this PowerPoint slide. And with this, I want to end this introduction, and we will pick it up in the class session by reviewing the applications of these standards in three situations. One is a court case brought under the Anti-Cybersquatting Act, and the other two are arbitration decisions involving the UDRP. So that's it. I will see you in class, and goodbye.